Hi, I'm Emily, and I am here with Maya Murphy's attorney, Lauren MacDonald. Maya Murphy has offices in both New York and Connecticut, and Attorney MacDonald is admitted to practice in both Connecticut and New York. Today, Attorney MacDonald will be answering some questions about suspension in New York. My question for Attorney MacDonald today is, what are my child's rights regarding a suspension hearing, otherwise called a 3214 hearing in New York?
Hi, Emily. That is a great question. Thank you. So when a suspension is for a period in excess of 5 school days, a school district must conduct a student suspension hearing, also referred to as a student disciplinary hearing or a 3214 hearing. And both you and your child must be provided written notice of the hearing. This notice must be provided before the suspension begins, and it must inform you and your child of the reasons why the school wants to suspend your child, the description of the misconduct and the date that it took place, and an explanation of your child's rights to a formal suspension hearing and the proposed date of the hearing. Your child may be assigned a short-term suspension in the interim before the hearing takes place. However, this can only be up to 5 days while they're waiting for the hearing date. If your child is suspended for 6 days or more without having the formal suspension hearing, he or she may be eligible to return to school pending a hearing. Now, if your child does not wish to contest the charges against him or her, they can choose to waive their rights to a hearing by entering a no contest plea or signing a written waiver. However, it is important to note before you or your child sign any type of document with the school district that you discuss your rights with an attorney so that you can make an informed decision about what you're waiving. If you and your child do decide to contest the alleged misconduct, at the suspension hearing, your child has the right to representation of counsel, the right to question their witnesses, the right to remain silent, and the right to present their own witnesses and evidence. Now, the hearing officer at the suspension hearing is authorized to administer oaths and to issue subpoenas if they choose to. Also, the suspension hearing must be recorded, either through audio recording or by written transcript. After the parties have presented their witnesses and evidence at the hearing officer will make findings of fact and recommendations as to the appropriate measure of discipline to the superintendent. The report of the hearing officer is advisory only, and the superintendent can choose to either accept or reject all or part of the hearing officer's recommendations. The Board of Education may then adopt in whole or in part the decision of the superintendent. If your child has been suspended and is of compulsory attendance age, it's important to note that immediate steps shall be taken for his or her attendance upon instruction elsewhere, or for supervision or detention of the student. Further, if your child has been suspended, the suspension may be revoked by the Board of Education whenever it appears to be for the best interest of the school and your child to do so. The Board of Education may also condition your child's early return to school and suspension revocation on your child's voluntary participation in counseling or a specialized class like anger management or dispute resolution. Now, you and your child may choose to appeal a suspension decision based on insufficient notice or a violation of certain rights. The only evidence that may be presented during an appeal is the record from the suspension hearing, the 3214 hearing. So it's very important to make sure that you present all relevant evidence at that hearing. Usually the student must first appeal to the Board of Education in his or her school district by submitting a letter explaining how his or her rights were violated and why they should reconsider the decision. If your child loses an appeal to the Board of Education, he or she may then appeal to the State Commissioner of Education. If you have any questions about your child's upcoming suspension hearing or potential appeal, please feel free to reach out. Thank you.